Okay, I call this meeting to order. This is the second meeting of the Standing Committee on Justice and Human Rights, and today we have invited officials from the Department of Justice to give us an overview of the justice portfolio. I am very pleased to welcome Donald Paragoff, the Senior Assistant Deputy Minister in the Policy Sector, and Alison McLean, the Acting Director of the Research and Statistics Division of the Policy Sector. And I understand they'll be giving us a 10-minute presentation, and then we're going to have some questions for you. So I'd like to turn the floor over to you, and thank you so much for coming to the committee.
Thank you very much.
I'm very happy to be here today to speak to the committee about trends in the criminal justice system. My introduction will deal with the federal-provincial territorial partnership, as well as points of tension within the criminal justice system. The criminal justice system represents a partnership between the federal government and the provinces and territories. Within this partnership, each of those parties has their own jurisdiction. The federal government is responsible for passing laws and regulations that have to do with criminal law, and the provinces are generally responsible for the administration of justice, including the prosecution of most offences listed in the Criminal Code.
Of Canada's criminal justice system. Neither level of government can successfully carry out its mandate without the cooperation of the other. As indicated, the federal government is responsible for adopting the criminal law, including criminal procedure, and the provinces, the provincial attorneys general, are responsible for its administration, except in the territories where the Federal Attorney General is also the Attorney General for those territories. In addition, the federal government provides cost-sharing support to the provinces and territories to provide programming in areas such as legal aid, Aboriginal court workers, victims, and policing. Given these shared responsibilities, the federal, provincial, and territorial governments recognize the importance of collaboration in the discharge of their responsibilities. Mr. Chairman, there are a number of challenges that I would briefly note are common issues across the whole of the criminal justice system, and where the federal and provincial and territorial governments could work together to attain greater efficiency and effectiveness. For example, despite a consistent decrease in the crime rate, criminal justice system costs continue to rise. Other areas of mutual interest include bail and remand, sentencing, the changing correctional population, and the overrepresentation of vulnerable populations, especially Indigenous persons and those with mental health and substance abuse issues. Mr. Chairman, we have provided a deck to the committee. The deck you have been given provides a great deal of statistical information on trends in the criminal justice system. I will not address each slide, but will refer to some of the key trends raised in the slide, and I may actually jump around a little bit to basically follow certain issues rather than slide by slide. Let me first talk about the rising costs of the criminal justice system. As can be seen on slides 3 and 4, in 2014, the police reported crime rate was at its lowest since 1969. There has also been a decline in the rate of violent crime, which has been steadily decreasing since 2000. Slides 5 and 7 highlight that there are regional variations in the crime rates, with the highest crime rates in the north, that is the territories, as well as the northern parts of the provinces. Statistics also indicate that many crimes are not reported. About 2/3 of crimes are not reported. This is a disparity between police-reported crime and victimization surveys. However, despite decreasing crime rates, the cost of the criminal justice system has been increasing over a 10-year period. All areas of criminal justice are seeing an increase, with policing seeing the greatest increase at 43%, followed by corrections, 32% increase, and the court system, 21% increase. Those stats are in particular on slide 3. Costs have been increasing in both the federal and provincial shares of the criminal justice system. Crime also has great societal costs. For example, the total economic impact of spousal violence in Canada in 2009 was estimated at $7.4 billion. And the total impact of violent victimization, physical assault, sexual assault, robbery, criminal harassment, and homicide is estimated to be $12.7 billion. I refer you to slide 8 regarding some other statistics and trends regarding victimization. I'd like to say a few comments about bail and remand, because this clearly is an area that the provinces and territories and the federal government are examining currently. In particular, you may want to refer to slides 11 and 12 for details. According to the United Nations, globally, 1/4 of persons in prison have not received a sentence or are awaiting trial. In Canada, however, for the last decade, more than half of those in provincial territorial custody are in remand. That is, they are not sentenced offenders, they have not had a trial, they are awaiting their trial. In 2013-2014, there were over 11,000 persons in remand. This can be seen in particular on the graph on slide 12. There has also been an increase in the number of days accused are spending in remand in some jurisdictions, most notably Nova Scotia, New Brunswick, and the Yukon. Recent statistics indicate that Indigenous offenders are overrepresented among those in remand, and that this overrepresentation is increasing. While Indigenous people represent only 4% of the Canadian population, Indigenous offenders accounted for 24% of all admissions to remand, up from 19% in 2005-2006. And as you can see in the graphs, there's, again, regional variation. While we lack a full understanding of what is happening with respect to bail, an older study from Ontario found an increase in the number of days required to actually make a bail decision, from about 4 days in 2001 to almost 6 days now in 2007. Even the time it takes, the system is also experiencing delays with respect to case length, particularly for certain selected offenses. One would expect that the decreasing crime rate and decreases in the number of adults charged for criminal offenses would lead to lower case processing times. Case processing times for cases in provincial adult criminal court, however, have in fact remained relatively stable over the last decade, and there has been an increase in case processing time for cases in the superior courts. Slide 13 provides some of the key points on case processing time. As indicated, there is variation in case processing time, with some offenses, such as crimes against the person and impaired driving cases, taking longer than other types of offenses. Cases in Quebec are also taking longer to process through the system compared to the rest of Canada, and I think that the graph before you shows that. In a study conducted by Justice Canada looking at closed cases from 2008 in 5 courts in 4 jurisdictions, it was found that 5% of cases required more than 2 years to be completed. The study also found that there were various factors related to the length of a case. Cases where legal representation was intermittent had the longest time to case completion at 298 days, compared to 189 days for cases with no legal representation, and down to 160 days when the accused had legal representation throughout the case, which shows that with counsel or with legal aid, the court delays are reduced. Not surprisingly, guilty pleas were found to reduce case processing time. The median case length was 58 days with a guilty plea and 190 days where there was no guilty plea. There are also, Mr. Chairman, specific types of offences which are prevalent in the system and are responsible for a significant amount of resources. Specifically, administration of justice offences, such as failure to appear or breaching probation, as well as impaired driving and theft, account for over 40% of the court caseload. Administration of justice offences as a proportion of all criminal court cases have seen an increase, up from 21% in 2006 to 26% in 2013-14. Slide 14 provides some statistics on administration of justice offences. As indicated, there has been a 4% increase in the rate of administration of justice offences that result in a charge that resulted in charge from 2006 to 2014. Administration of justice offences are also more likely to result in a guilty plea or guilty decision when compared to the average for all other offences. The most recent statistics indicate that half of these offences also receive a custodial sentence, which is higher than the proportion of custodial sentences for crimes against property and crimes against the person. In 2014, the highest rate of administration of justice offences were found in the Northwest Territories, the Yukon, Saskatchewan, and Nunavut. These jurisdictions also have higher rates of Aboriginal people in the criminal justice system, and although there are no national statistics on this, some research has found that administration of justice offences are overrepresented among Aboriginal people. Just to explain what administration of justice offences are, Mr. Chair, for the committee, they include offences of breach of a bail condition or breach of a probation order. Bail conditions can be specific to the offence, but they can also be basically conditions of good behavior. Do not drink, keep the peace, a curfew, be into your home by a certain time. And breaches of some of these conditions, if they are charged as criminal offences, can result as a criminal offence, even though drinking alcohol, coming in late, are by themselves are not criminal offences themselves. They elevate to criminal offences, and people get criminal records quite often not because they've actually committed a crime such as theft. They may be in court for the first time for theft, but then they have a whole host of other breaches for things like breaching a curfew, drinking alcohol when they're supposed to abstain, etc., and they end up getting a long line or list of criminal offences. I'd like to then talk, Mr. Chairman, about sentencing and corrections, things that happen at the back end of the system. Some of the statistics that I will be speaking to are not found in the deck. These are we didn't really have much time. We only had notice as I think of Friday for this appearance, so we weren't able to put everything together in the deck before you. The provincial territorial correctional population has seen a decrease in the average number of offenders in custody and on probation. As I indicated earlier, more than half of those in provincial custody are there for remand, not serving a provincial sentence. And for your benefit, provincial sentences are those which are less than 2 years. Any sentence to be served over 2 years is served in a federal penitentiary. The majority of custodial sentences in the provincial system are less than 6 months, with the median length of probation being around 1 year. With respect to the federal correctional population, there has been a 14.6% increase in the average number of offenders serving a federal sentence over the last 10 years, with just under half serving a sentence of more than 5 years. The federal custodial population is also getting older, with 23% of those in custody aged 50 or over, compared to 19% in 2010. Additionally, the number of women admitted to the federal jurisdiction has increased at a rate higher than that of men. In the last 10 years, there was a 39% increase in the number of women under federal jurisdiction, compared to a 12% increase for men. I want to spend some time, Mr. Chairman, talking about vulnerable populations, because the criminal justice system is having a significant impact on these individuals. As I mentioned, there is an overrepresentation of vulnerable populations within the criminal justice system, most notably the Indigenous population, as well as persons with mental health or substance abuse problems. Slides 9 and 10 address chronic offenders and give you some details with respect to who constitutes the chronic offender population. And essentially, these are a small number of offenders who account for a large number of reported offences in the system. Slides 16, 17, 18, and 19 in particular present statistics and trends regarding corrections and Indigenous people. According to the most recent census information, just over 4% of the Canadian population is Indigenous, nationally that is. Yet Indigenous people account for 20 to 25% of individuals across various points in the criminal justice system. These rates, of course, vary with significantly higher rates in Western Canada, where there is higher rates of Indigenous population, and of course in the north. While crime rates vary across the country, there are disproportionately high rates of crime in jurisdictions such as the territories that have larger Indigenous populations, with the highest crime rates occurring in the Northwest Territories. Recent statistics indicate that Indigenous offenders accounted for 24% of all admissions to remand, up from 19% in 2005-2006. Additionally, the proportion of Indigenous offenders admitted to provincial and territorial sentenced custody has increased over the last decade and is currently at about 1/4 of all adult males. The most recent statistics indicate that more than 1/3 of adult women admitted to provincial territorial sentenced custody were Indigenous. I can indicate more with respect to the stats, but you have them in front of you. Given that a large number of the Indigenous population compared to the non-Indigenous population are young, and crime is definitely based on a youth-based phenomena, it's expected that these rates can rise in future. I want to just say something about modernizing the criminal justice system as conclusion. The communal doubt that society has evolved significantly in the last few decades. The issues we face today are significantly different from those of previous generations. The Prime Minister has mandated my minister to review changes to the criminal justice system and sentencing reforms over the past decade to modernize efforts to improve efficiency and effectiveness in the system. The Minister of Justice is mandated to take a hard look at the justice system, specifically identifying what works and what doesn't. Key to modernization is understanding that the current system seems to have an impact on certain populations more than others, both as offenders as well as victims. Many offenders, whether Indigenous or not, have some combination of mental and addiction problems. Questions: what if Canadian society did a better job of treating mental illness and addictions at the front end? This could have a significant impact on the justice system at the back end. Many people feel that the justice system is the default system for society's social problems. The question is, can we change the system? Can we better align it with the needs of offenders and victims? What if an offender's first interaction with the justice system didn't become the first in a series, for instance, of repetitive encounters with the justice system? What if the justice system triggered mechanisms up front that were designed to actually address the factors that inspired the criminal behavior in the first place? These are the fundamental questions that I think are before Parliament and before the provinces and territories. In conclusion, the criminal justice system is one that incorporates many independent systems and many players. Actions by one level of government or actor within the criminal justice system have an impact on another level of government and on other actors. Il est important d'examiner le système de justice pénale sous cet angle.
It's important to examine the criminal justice system from this angle when we are trying to find ways to ensure that the criminal justice system be effective and fair and reflecting the current situation.
Default responder to provide solutions to mental health challenges upstream. More can be done to address these social problems, and we're working with the provinces to actually look at innovative ways to address social problems in the justice system. These are just a few of the highlights, Mr. Chairman, of current trends in the Canadian criminal justice system. Should the committee be interested in more detailed criminal justice trends and statistics, I'd invite you to speak to the Canadian Centre for Justice Statistics, which is part of Stats Canada, to provide a presentation. In addition, the Corrections and Conditional Release Statistical Overview produced by the Department of Public Safety is also available online. Their latest version is 2014 and 2015 stats are to be published shortly. Thank you.
Merci beaucoup, Monsieur Piragoff.
Thank you very much, Mr. Piragoff. It was a real pleasure to listen to your presentation, and thank you for that very detailed information. So we'll start to the first round of questions.
The committee has adopted a process for questions. In the first round, we're going to start with 6 minutes from the Conservatives. We'll go to 6 minutes from the Liberals, 6 minutes from the NDP, 6 minutes from the Liberals. So we're going to be starting off with Mr. Nicholson. Mr. Nicholson.
Thank you very much, and thank you, Mr. Paragraph and Ms. McLean. And I know, Mr. Paragraph, you've had a great career in the Justice Department, spanning several decades. And thank you very much for your insight today. It's much appreciated. One of the interesting comments and things that you pointed out is that, yes, there has been increases in the expense within the criminal justice system. I mean, certainly some of that, of course, is attributable to inflation over the last 10 years, so that would be expected in just about every. But I think we could also make the case that when we do spend money in the criminal justice system, that it overall has a positive effect with respect to the administration of justice and indeed even the crime rate in terms of moving forward on those. That being said, you made a couple of interesting points, one of them with respect to bail. And I'm not quite sure why that has continued to increase the times. There were those who made the case a number of years ago that when the 2-for-1 credit for people while they were waiting for their trial or the disposition of their case would get a credit if they were being detained in provincial institutions or in custody, but with the removal of that as a main factor in terms of the overall sentencing there, what other insight do you think you may be able to give into us? What's happening? I mean, you made the very legitimate point that if the individual pleads guilty, that the disposition is actually fairly quick, but that makes sense. But I'm not quite sure what's happening within the system that it's taking so much longer for individuals to get bail or get released or get their case heard. I think you pointed out that Nova Scotia in particular and others, there's been a considerable increase over the last number of years. Any thoughts on that?
We don't have statistics, but we have a lot of anecdotal evidence from individuals in the system indicating that they feel that there's a reticence to actually make bail decisions. Police officers are reluctant to release when they have the power to release because they're afraid that if the person should offend while out on bail, they'd be responsible. The same thing happens even with Crown attorneys, so they keep on pushing things up the line to the judge, and so let the judge make a decision, so I don't have to accept the responsibility. So that's one of the factors that a number of people in the system indicate. With respect to times, there is some new data that we're looking at with respect to Ontario and Saskatchewan that seems to show that the majority of people in remand are actually out within a couple of weeks. And it goes to the question of the credit. Quite often they're in for a couple of weeks, they plead guilty, and their sentence is essentially time in custody. And there's no further sentencing. And again, that again is sort of reflected in the statistics, which seem to show that most of the people who are in provincial custody are there for remand purposes and not custodial, either because there's a booming remand population, or people do their remand time and their sentence is the time spent already in remand, and there's no more further sentence custody. So sentence custody goes down proportionally.
Can I ask you get one comment from you with respect to impaired driving? There have been increases over the years with respect to the penalties related to impaired driving. An individual who is convicted of impaired driving faces very serious consequences in the sense that they have a criminal record, and this can have great consequences in their lives. Now, I noticed that, and I've heard this from law enforcement agents, that the cases are taking considerably longer than they did years ago. Do you attribute this to the increase in penalties, or do you think there are complications with respect to the production of documents? I've heard this again and again, that it's taking longer, and can you think of anything that we might do? Might we revisit the whole area in that area of the criminal justice system to either expedite it or making sure that it works for everyone's benefit?
Thank you. There's no one reason. There's likely a combination of reasons. If penalties go up, of course they become more severe. There's more of an inclination as to wanting to fight the case. And it's not so much the criminal penalties, it's more the provincial penalties that people want to fight, because the provincial penalties, you lose your car. The federal penalties, you lose your license, you pay a fine for the first time, but quite often the provincial level, you lose your license for a long period of time. But there's also been changes in terms of the actual processing procedures. Parliament enacted legislation a few years ago, and the result was there was a significant amount of litigation, charter litigation, with respect to those new laws. In particular in Quebec, and I indicated earlier that Quebec, there's been a significant increase in trial delays. Some of that may be attributable to the fact that many cases were put on hold. Impaired driving cases were put on hold pending certain key appellate decisions working their way up through the Court of Appeal and the Supreme Court of Canada. There are a number of novel defenses that people are raising tied to the Charter. So there's a combination of factors with respect to what's driving impaired driving rates. The other important thing about impaired driving, why it has been successfully over the years bringing down the rate, it's been a combination of things. It's not just the penalty; it's also the likelihood of conviction, but more importantly, the likelihood of apprehension. That's why those RIDE programs are really important, because what stops people from drinking and driving most is a fear that tonight I may get caught because the RIDE program is out. Other times, people are willing to take a chance.
Thank you very much. Mr. Biddle.
Thank you so much, and thank you for your presentation. You mentioned that, and I just want to clarify this, that there was a significant increase in federal prisoners, but a significant decrease in crime. Is that correct?
The general crime rate has been going down over the years, yes.
And what's the cause?
I can't. I mean, it would only be supposition on my part, but a number of things. There has been clearly the mandatory minimum penalties have had an effect of moving people into provincial sentence custody to federal institutions. Some of the sentences at the federal level may be longer, as indicated. There has been an increase in the length of sentences as well. Whether that is attributable to mandatory minimum penalties, or whether that is also attributable just to judicial discretion, or a combination of both, it's really hard to actually say what the reason is for the increase.
I've practiced in the civil context for the last 10 years, and it's only anecdotal evidence on my part, but I've seen back home in Niagara an increase in the time frame for civil, and I hear from my family colleagues as well, to get to trial at the Superior Court level. And anecdotally, it's because of increases to get to trial on criminal matters, as they take preference and priority because of charter issues and whatnot. And is there any evidence, or have you heard has there been any study into the fact of whether mandatory minimums are leading to less access to justice in the family or civil side of our justice system?
I don't think you can say MMPs have a direct impact on the civil justice system. Clearly, MMPs have an impact on the criminal justice system in terms of, as I said, people are going to fight the case more if there's clearly a set penalty that they know that they have to try to avoid. That then, of course, might increase trial length or the number of trials. And if people are in custody, then clearly there are charter issues that those people have priority to the trial system and to courtrooms and judges. So of course, If that means chief judges have to reassign judges from the civil side or the family side to the criminal side, then clearly it would have an impact on the civil justice system.
Okay. Colin, would you like to?
Still have approximately 3 minutes and 15 in this sequence, so Mr. Fraser.
Sure. Thank you very much for your presentation. Wondering, and you touched on the mental health aspect and obviously people being having social problems with drug use, addiction, that sort of thing. Wondering, what do we know about recidivism where mental health and drug courts are present? And how many are there across the country? I know where I'm from in Nova Scotia, there is a drug court, and I'm wondering if we know any statistics on how that has an impact on repeat offenders.
We've got the statistics. I don't have them at my fingertips, but if you'd like, I could provide them to the committee. There were 6 drug courts that were funded by the federal government as a pilot project. Some cities, such as Calgary, have their own drug court, which they fund themselves. So there's not a uniformity of funding. The federal government has expanded the number of courts that it is co-funding with the provinces. The one in Nova Scotia, for example, is a new one that the federal government just started to co-fund, I think, this last year. The research, and I can provide the committee, if you like, with a copy of it. The research that we've undertaken with respect to evaluation of the drug court system is that they are costly. It's an expensive court system, but those who graduate, and even those who don't graduate, who actually go through the system but maybe actually fail, have lower recidivist rates. So the drug court, the drug treatment courts do seem to work, but it's a costly process.
Do I have time for another question? With regard to, I'm just wondering about conditional sentence orders. The incidence of people repeat offending or recidivism while people are serving conditional sentence orders. Have we seen any change in that, and how does that compare to recidivism for those who actually served custodial sentences?
I'm not aware of the stats or whether we have comparative stats. Allison, do you know? I'm not aware if we have stats comparing conditional sentence offenders to other types of offenders. We can check to see if Stats Canada has something on that.
Okay. Just on the bail piece, more than half are in remand rather than actually sentenced to actual custody. Is that's correct, what the case is? And do we see any correlation between resources in legal aid? Has it been investigated what resources in the provinces that have higher incidence of people on remand versus the resources in the administration of justice at the provincial level, for example, in legal aid? Has that ever been explored?
We have rates of legal aid province by province. We have the remand rates. I don't know if that actually correlation someone has actually evaluated province by province if there's a correlation between legal aid and remand. But as I indicated in the stats that I did mention, where legal aid is present, court processing times are significantly delayed, which means that if a person is in remand as opposed to on bail, that it would definitely have an impact in reducing remand custody time.
Okay.
Thank you very much. We're going to move to Mr. Rankin.
Thank you, Mr. Fairgoff. An excellent presentation. I had a number of specific questions, but maybe to pick up on where Mr. Fraser left off on legal aid. Have you statistics on the number of unrepresented accused in courts? I'm hearing anecdotally from judges that there's, in my province, British Columbia, a huge increase in the number of people who are appearing without counsel, and I want to know what that means in terms of costs and in terms of the kind of delays and lengths of trial that might result.
I don't have the numbers on hand. If you'd like them, Mr. Rankin, we can get those. But there is anecdotal evidence that the number of unrepresented persons is increasing, not only in the criminal justice system, but also in the civil system, in particular the family law system.
As a function of lower legal aid access opportunities, I presume.
Well, that's part of it, yes.
And no stats on which that you're aware of that would talk about the increase on length of trials that results from that? If you're not represented, do you have shorter trials or longer trials?
If you're not the stats that I mentioned earlier in my presentation, if you're not represented, the trial takes longer.
Right, I would have. And just for definitional purposes, most of us are new on this committee. When you speak of administration of justice offenses, what does that term include?
Breach of a bail condition while you're out on bail, or breach of a probation order.
Those are the two main
They're both
things.
the two mains. So
Okay.
it's either up front or it's after sentence and you breach a probation order. And conditions vary. Some police officers and some judges, it's could be like some 20 conditions on a bail order. Like it becomes a boilerplate.
Yeah.
And the real question that a number of judges are now talking about, particularly chief judges, is that there should be more fine-tuning of the conditions to the actual offender, less boilerplate and more custom conditions, which actually makes sense, because it really makes no sense to impose a condition on an alcoholic, do not drink. I mean, you're basically setting the person up to fail, and you're setting the person up for the police to essentially arrest the person, and now if he gets convicted of breaching the administration of justice charge, he's now got a conviction for essentially a social problem. He's an alcoholic.
I understand the example. A couple things about the statistics I just wanted to ask you about. On page 5, you set out the overall crime rates, showing, of course, there and in the next slide that they're much higher in the north. And I wonder if some of that has to do with a greater propensity to charge or greater reporting that might occur. Just in general, the stats are much higher in the north, as you point out. And I wondered, aside from the difference in the population, more Indigenous people you mentioned, but could this just be better stats on reporting, more charging opportunity there? Why would that be?
We don't have very good statistics on that issue, but the research and the data do show that the northern parts of the provinces also have high crime rates in between those of the territories and the provinces. Of course, crime is affected by many factors, including, economic factors, unemployment rate, lack of education, lack of employment opportunities. So we typically find that those factors are more prevalent in the territories and the northern parts of the provinces.
There's a statistic about sexual assaults, and the third bullet, I just need a clarification. It says for sexual assault, 83% of incidents were not reported to the police, while 5% of incidents were reported. Is there a gap there? I'm just not sure logically where the other percent goes.
12% of the respondents did not answer or did not know if they had reported it to
so
the
that
police.
would cover it all. I see. Okay. The other question I had, I'm not sure if I've got any more time, Mr. Chair.
Minutes left, Mr. Rankin.
Okay, thanks. On page 11, the last bullet talks about the bail issue, and it makes the point that criminal justice professionals have noted an aversion to risk reduces discretion at all stages of the bail decision-making process. I understand that. So is there a recommendation that results from that observation?
Yes, the federal government works together with the provinces in a number of fora, at the ministerial level, at the deputy minister level, and also at the officials level. And the federal, provincial, territorial ministers of justice have approved some recommendations coming from officials that greater discretion should be given to police officers at the front line. Right now, there are certain types of situations where even the police officer must send the case up to an officer in charge as opposed to he or she actually dealing with the situation. So one of the proposals is to give greater discretion to the frontline police officer to release on conditions as opposed to passed it up the line. Now, whether that, of course, is going to psychologically affect the person's reticence, I think that's going to require a lot more training for police in terms of how they exercise their discretion and when it is appropriate to release it or when it is appropriate to pass the person to the next level of processing.
And given that so much of our policing is done by the RCMP on contract, is that training or that additional discretion, if it were to be bestowed on police officers, be something that would be done at RCMP headquarters, or would that be a provincial initiative due to their administration of justice responsibility?
I think most of the policing actually is under provincial control.
Yes.
Quebec, Ontario have provincial police forces. Municipal police forces are again provincial control or municipal control. The RCMP really is only contracting and essentially is contracting in the Western provinces and the Maritimes.
Okay, thank you very much, Mr. Rankin. On va retourner à Monsieur Fraser.
Go back to Mr. Fraser now.
I just have one more question, and then I believe there's other questions from our side. Just with regard to the Gladue factors, it appears as though they're not having the impact in reducing the representation of Indigenous people in custody. Are the Gladue reports being utilized, and are they accessible across the country as envisioned, I guess, in the Gladue response?
We're just starting to undertake research in the area of impact of the Gladue reports, and there is variation across the country. Ontario, again, even within provinces, there's variation. Certain parts of Ontario, the Gladue reports are quite regular. In other parts, they are not. Some provinces, they are not that. They are not being utilized that much, despite the fact that some of those provinces have high Indigenous populations.
Okay, and if I could ask just one quick follow-up. So where they are used, where Gladue reports are being utilized, do we see any reduction in custodial sentences?
Alison, do we have research on that yet?
No, we don't have research that would point to that.
Okay, thank you.
Ms. Khalid?
Thank you. That was a very good presentation. Thank you very much for coming in and speaking to us about this. I'm wondering, just listening to the questions of our peers here and your responses as well, I'm wondering how is this information collected? How are these stats put together based on what information?
I'm going to let Alison, how are the stats put together? Where do they come from?
The best source of national statistics is, in this area is the Statistics Canada, the Canadian Centre for Justice Statistics. It obtains the information through the National Justice Statistics Initiative, which is a partnership with the provinces and territories. The Canadian Centre for Justice Statistics collects national policing data, courts data, and corrections data. However, there are gaps, and some of those have been noted during this session. Additionally, there are academics who provide other sources of information to us.
And how often is this review or collection or compilation of information done? Like, is it a yearly basis, every couple of years, or?
The police, courts, and corrections data are provided annually. In addition, I might mention that Statistics Canada does a victimization survey every 5 years. That is a source of information on crime that is not reported to police. And the most recent one was conducted in 2014. Okay.
And I had very similar questions as to my colleagues with respect to remand times and why they're increasing. What is your recommendation apart from what would you recommend that would help to decrease remand times and the cost of administration of justice?
Well, as Acting Director of Research and Statistics, I would like to see better data in this area, of course. To my mind, the best decisions would be data-driven. However, there are certain challenges, of course, to obtaining this data in a timely way to inform decisions.
we are looking at, the department is focusing right now, along with some of the provinces and territories, on the administration of justice offences. And the question is, could there be alternative measures as opposed to laying a criminal charge for the administration of justice offence? Would it not, for example, with a conditional sentence, as Mr. Fraser raised, one of the methods to deal with conditional sentences is to bring the person back before the court, not to charge them, but to bring them back before the court, and essentially the judge to ask, so, why are you here? Why did you breach a condition? I can send you to jail. What's going on? Some people say that maybe the same kind of process should be done. I think there's an Australian state, could be New South Wales, has a process where, for administration of justice offence, the police officers can give a warning rather than charge. The person can be brought before the court, not for a charge, but just brought before the judge, so the judge can essentially say, like, why are you here? Why are you breaching your curfew? And the person may have a good explanation of it, because I got a new job, and the bus schedule is such that I can't get home any earlier than when I get home. So why charge the person? So that, you just change the condition then. So there are some. We are looking at what other countries are doing in terms of how they handle administration of justice offences, so that we can actually maybe avoid some of these, what would say, needless charges and needless convictions and people getting huge criminal records. Because what happens when you have a series of convictions and you have a series of convictions for administration of justice charges, the judge looks at the record and say, well, I can't let you out because you're not reliable. If I let you out, you're going to just breach. But the problem is the record doesn't actually show what was the reason for the breach. It just simply says breach. It doesn't say you breached your condition because you got drunk and you're an alcoholic. And the condition says abstain from alcohol, which is, it's a condition that's setting the person up for failure.
So thank you. We've now completed our first round of questions, so we're now going to move to our second round of questions. In this round, we have 6 minutes to the Liberals, 6 minutes to the Conservatives, 6 minutes back to the Liberals, 5 minutes back to the Conservatives, and 3 minutes to the NDP. So, Mr. Hussain.
Thank you. Thank you, Mr. Chair, and thank you, Mr. Perago, for coming in and giving us a very valuable presentation. I just have a question, two questions that are related both to the bail issue. As a former criminal defense lawyer, bail was one of the things that concerned me greatly because, at least as far as Ontario is concerned, the legal aid system, the way it's structured, does not, tends to discourage criminal defense lawyers from taking on bail because you're not sure if the person will be approved for legal aid or not. So I'm just wondering, in terms of the bail issue, has your department looked at how the structure of legal aid programs across the country affects the person's ability to access those programs, and how that affects their right to, how the ability to get representation, which affects their ability to get bail? Because when you don't have representation, it's hard to put together a good case for release. So is that something your department has looked at?
Thank you. Mr. Chairman, your schedule of 6 minutes and 3 minutes, 6 minutes, I feel like I'm in the penalty box. I'm not sure when I'm on the ice and when I'm in the penalty box.
Rules, you're doing fine.
Yes, we're working with the provinces. As you know, the administration of justice and legal aid is a provincial responsibility. We are working with the provinces to undertake best practices, and we actually undertook a study a couple of years ago on innovations in legal aid, to see what kind of best practices. Each province has a different means of delivering legal aid. Some use a certificate system, some use more in-house legal aid lawyers, which are government lawyers. Others provide certificates to the private bar. Some jurisdictions have a mixture of both in-house legal aid lawyers and private bar. We are looking at that issue, and if the committee wants, we can give you a copy of that report on legal aid, innovations in legal aid, that we undertook a couple of years ago. It was an interesting report because what we did is we got a number of key individuals from other sectors of society. For example, the head of the Ottawa Hospital, to actually sit on the board and use the sort of the experience that they did in terms of reducing wait times, etc., in the hospital system, and what kind of innovations they use there, and could they also be applied to the criminal justice system to see if we could learn from innovations in other parts of society. So it's an interesting study, and we can provide you with a copy of that.
You have more time, Mr. Hussain, if you want to continue?
No, that was my question. Thank you.
Okay, thank you. So are there anyone else on this side who wants to continue this round? You have about 3.5 minutes. Mr. Biddle?
Going back to the issue on incarceration rates for vulnerable persons and vulnerable populations, have there been any pilot programs that have been run by the department or through the provinces that have shown some success that can be replicated on a broader scale?
Yeah, one of the funding programs that the department has is the Aboriginal Court Worker Program. It's about 180 court workers, which are spread out across the country. Some of them are co-funded with the provinces. These individuals are sort of the liaison between the individual and the court system, whether the individual be the offender or a victim, to essentially help them understand what the court process is about. For many of these offenders, the court system is totally a foreign culture to them. For example, on the administration of justice offense issue, this is purely anecdotal, but I was told by one director that in order to reduce the number of breaches of administration of justice offenses because of failure to appear, the problem was that the closest courthouse was miles away from the reservation, from the band, and people weren't appearing in court because they couldn't get to town. So the court workers got a school bus and went around on court day and picked up everybody and took them to court, made sure that they made their appearance, and then drove them back to their home, which again was an innovative way of ensuring that people were not being charged for failure to appear when it wasn't anything intentional. It was just simply they had no means to get to town.
As a student at Queen's, I had the opportunity to participate in a sentencing circle as a representative of the university, and a couple of students, instead of being charged with a property crime, were diverted into a program like that. And I was disappointed after law school I never saw that again. It seemed to be, again, anecdotally in that one instance, seemed to be an effective way to get people out of the criminal justice system for a first offense or minor crime. Has there been any reports on that, or any discussion on that, or any findings on alternative methods such as that?
I'm not sure if there have been formal studies, but I know that the sentencing circles are not used as much as they were in the past. And of course, in some places, they're just not appropriate. I mean, it doesn't make sense in downtown Toronto. It really only makes sense where there actually is a community, a well-known community. I know that the Yukon or Northwest Territories were using them for a while, a number of years ago, but I think that they're using them less and less now. I'm not sure why.
You have about 20 seconds, so if you have a really fast question.
I don't know that I have a 20-second fast question, but because there won't be a...
Mr. Fraser, 20 seconds?
Just on a quick follow-up, restorative justice exists in some places, usually for youth. I know there's a move in Nova Scotia to incorporate that into for adults as well. Can you comment on restorative justice principles and how they are effectively managed across the country?
They are a provincial responsibility. So in terms of management of the programs, it's provincial. There is a lot of people who are saying that some of the successes in the youth criminal justice system, such as restorative justice, diversion, should probably be maybe used more regularly with respect to the criminal justice system, particularly for low-level offenses. And offenders who are non-violent and first-time offenders, that maybe some of these people should be diverted out of the system as opposed to getting a criminal charge and then they're in the system, and then it's one thing after another.
Thank you. Mr. Cooper.
Thank you and good morning. I just have a couple of questions related to Indigenous offenders. First of all, I just want to clarify one statistic that you had mentioned with respect to Indigenous persons in remand. You had indicated, I believe, that it was at somewhere at 24% of the remand population in Canada, and you had also cited another statistic that Indigenous persons represent about 25% of the prison population that is incarcerated upon conviction. So in other words, there's no differentiation between those Indigenous persons in remand and that are incarcerated upon conviction. Did I hear you correctly on that?
I'd have to double check the statistics to get back in that, to see if they're exactly the same. Alison, did you have that? I'm not sure.
We know that at all levels of the criminal justice system, Indigenous peoples represent 20 to 25% of the overall population. That's all I can say.
Okay, so you now at page 19 of your presentation, the first bullet point states that if nothing changes, approximately 1,000 more offenders will be in federal custody in 10 years. Could you elaborate upon how you've come to that figure, and also how that can be addressed? What do you mean by if nothing changes? By what should change?
Well, as I mentioned earlier, there are a number of factors that affect the crime rate. So the economy, employment, so those sorts of factors would influence the crime rate, and more specifically the rate of Indigenous involvement in the criminal justice system. Other changes could be some of the things that have been raised earlier with respect to policies or legislation.
And what about the significant number of programs for Indigenous persons that the federal government provides in terms of funding levels, etc.? Would you be able to comment on that?
I mean, the phrase "if nothing changes" essentially is if the status quo remains as it is, which includes the existing programs. In other words, they're not augmented, they're not increased. If things just stay the way they are, given the rates, given the demographics, then the prediction is that there will be an increase in federal custody, unless measures are taken to either increase programs or undertake other measures to basically bend the curve.
Now, at page 16 of your presentation, there's a chart on Canada's incarceration rate per 100,000 people. What is this statistic from? When is this statistic from? And has there been any trend in terms of over, say, the last 10 years of what the level of incarceration is in Canada?
These are data that are provided to the United Nations by the countries identified.
But what about, are you able to comment on whether there have been any trends over the last 10 years or so in terms of, have we seen an increase, for example, in the incarceration rate in Canada?
There has been an increase in the incarceration rate in Canada. However, I don't know how it compares to the increases or decreases that may have occurred in other countries identified here. But we can get you that information if you would be interested.
And you're not able to comment on, you've just said generally there's been an increase, but you don't have the statistical data on what that increase has been.
I don't have that information at hand. Thanks.
Is there any other, we have another minute and 20, Mr. Falk or Mr. Nicholson? Or Mr. Cooper?
I mean, I can ask one final question. I mean, certainly in your statistics, you note that chronic repeat offenders are responsible for a large volume of crimes, that there has been, over the last 10 years or so, a marked decrease in violent crime, and then a 32% increase in corrections cost over roughly the same period. So isn't it the case that those who commit the most violent crimes are not committing them because they're behind bars? I mean, there seems to be some logic in those figures in terms of why that may be.
One of the justifications for mandatory minimum penalties is the incapacitation principle or denunciation. Evidence, we don't have evidence that shows that MMPs have a deterrent effect, but they clearly have an incapacitation effect or a denunciation effect by society. So yes, if a person is locked up, then they're not on the street, but MMPs do not have the same effect with respect to drug trafficking. You pull a drug trafficker off the street, there's an economic incentive there, the void is filled. As long as there's a market for someone who wants to buy drugs, there'll be a new person coming along to push the drugs if you take a person off the street. So it depends on the crime as to whether or not what effect penalties have.
If it's okay with my colleagues, I'm just going to take 1 small second of the Liberal time that's coming up that will start now to ask a follow-up to Mr. Cooper's question related to page 19. Just for clarification, my understanding based on what you're saying on page 19 is simply that because the percentage of Aboriginal Canadians is estimated to be increased from 4.6 to 6.1% of the population of Canada, and based on the fact that many of those people, because of the birth rate, will no doubt be young, based on the existing percentage of incarcerations of Aboriginals, based on that population increase, that's where you're estimating the 1,000 extra prisoners in 10 years. Is that not correct? I think it's simply based on demography is what you're saying.
That's one factor is pure demographics. The other factor is that if everything else stays the same in terms of the amount of money that is put in, programs are not increased, despite the fact that there is an increase in population, then there will be an increase.
Right, if nothing else changes based on demography.
That's right.
Got it. So moving to the Liberal side, who's going to lead on this round? Mr. Casey.
Thank you, Mr. Chair. I want to drill down a little bit on the remand issue. That's one trend that you identified, and seek your advice on just what is the explanation for the increasing population on remand. I guess I can think of some reasons why we're seeing this. If I could set them out, perhaps, and invite you to let us know which ones are identified as being behind this. So, my expectation is that people are spending more time on remand because we're seeing more not guilty pleas, perhaps because of sentencing reform, perhaps because of some other reason. An inability to meet onerous bail conditions, a backlog in matters getting to trial would lengthen remand periods. As you indicated, the proliferation of offenses related to the administration of justice, and the funding challenges within legal aid. So, to my mind, those would all be factors that would be relevant on remand. I invite you to respond to that. Are there some factors that are missing? Are there some that are more prevalent than others? I think for us to be able to address the issue of the expanding amount of time that people are spending in remand, it would help to get your advice on what the key factors are that are playing into that.
All the factors that you've mentioned, Mr. Casey, are relevant factors. Are one of those more important than the other? I don't know. I'd have to check to see if we have research which has actually seen if some factors are more important. I mean, there's also another factor, which is discrimination. You know, to what extent is discrimination play a role in the fact that certain individuals are in the system. The mental health one is a significant one as well. Fetal alcohol syndrome, for example, is a big factor with respect to some populations. In particular, not only offending substantive crimes, but also administration of justice offenses, just because of the effects that syndrome has on people's ability to remember dates or to follow instructions, etc.
Completely changing gears here, there was the most recent set of stats that were publicly released related to youth justice. Can you give us a high-level account of what those statistics told us, and what we can learn from the most current information with respect to youth criminal justice?
Well, we do know that the number of charges are going down. The youth crime rate is going down. I'm not really prepared to speak to any of the other more detailed statistics, but I'm able to get that information to the committee. There's an excellent Jurostat from the Centre of Canadian Justice Statistics.
One of the problematic areas you identified in your earlier remarks is the disturbingly high incidence of impaired driving, and we've seen various measures taken by provincial governments as well as the measures contained in the criminal code to address this. I'm looking for your advice in terms of best practices. Are there provinces who have adopted measures that have been effective? Are there jurisdictions that we can look to try and reduce the incidents? Are there tools other than what the federal government has done in the criminal code where we can show leadership to address this?
British Columbia, for example, rarely uses the criminal code for the enforcement of impaired driving. They are using their own provincial administrative schemes, whereby there is instantaneous suspension of the license and actually impoundment of the car at the roadside. So they're basically using the criminal code provisions only for repeat offenders or very serious repeat offenders, but for the first-time offenders, they're using their provincial administrative legislation. And I understand from statistics that they have that has had a significant impact on the impaired driving rates. And again, it's because, as it indicated earlier, it's not just simply a question of penalty, it's also a question of how quickly the penalty is imposed proximate to the offense. And when you get the penalty right at the roadside, you feel it right away. It's not like something happens 10 months later and you go to court. And in fact, probably the biggest pain of going to court 10 months later is not the fine, it's paying the lawyer's fee.
Very much. We definitely agree with that. Coming back, Mr. Falker.
Good. Thank you, Mr. Chairman, and thank you to Mr. Paragoff and Ms. McLean for coming here and providing testimony this morning to our committee. I've been intrigued with several of the statistics that you have highlighted here to the committee, and so I do have a couple questions I'd like to ask. And some observations, and you can correct me if I'm wrong, but one of the observations that or statements that your report has made is that there's decreasing crime rates, and is it fair to assume that the legislation that's on the books that the previous government was very instrumental in introducing has contributed to lowering crime rates? Is that a fair assessment?
It's very fair.
I can't say whether it is or not. The trend has been going down. It's still going down. Has that contributed? Maybe. Has it not? Has it had a neutral effect? I don't know. Clearly, the stats show that the trend is still going down.
That's certainly what your data shows, yes. Thank you. But I do notice that the costs have been going up. And over the 10-year period that you cite from 2002 to 2012, I don't know if it's a 10-year period or 11-year period, but you're citing costs of 36% interest or 36% increase in costs for the criminal justice system, 43% in policing costs. Can you comment any further on why those costs have increased more than the rate of inflation?
So Public Safety Canada has undertaken some studies in this area. And a lot of the increase in the police costs is associated with the fact that I indicated the system has become the default for other default of failures of other parts of the social system. So police officers are spending a significant amount of their time dealing with people who have mental health problems or other types of problems. So, you know, if you take a police officer takes a person to the hospital because of a suspected mental health issue, that police officer may be there for a couple hours while they're waiting in the hospital. So that's a significant amount of time that becomes a police cost when it's not actually traditional policing costs in terms of investigation. It's essentially being a social worker. So the police will say a lot of their increased costs is because they're becoming more and more social workers as opposed to law enforcement officers. Correctional costs, it makes sense if there are more people going to penitentiaries and jails and they're staying there longer, then of course the correctional costs will go up. Costs of the system, if trials take longer, which we indicate, then of course it's a greater cost for prosecutors, judges, etc., because their time is being eaten away with respect to lengthy processing, as opposed to moving people through the system more quickly.
Thank you. And also wondering, one of the comments that your report made is that over 50% of the people that are currently incarcerated have not been convicted. Has your department worked on any initiatives to change that?
That's in provincial custody. It's 50% of those in provincial custody are there for remand purposes, as opposed to undertaking a federal sentence less than 2 years. Now, in part, the remand custody may be actually increasing. In part, it may be the provincial sentenced custody has decreased. I did indicate that with MMPs, the effect has been that some people are automatically pushed to the federal system, which means they go to penitentiary. So if they're convicted, they do not undertake any sentence in the provincial system, they go to the federal system. So of course that would have the effect of changing the proportion between sentenced offenders in provincial custody and those in remand. So there are a number of factors going on at the same time.
I would. My time is quickly slipping away here, and I've got lots of questions, so I'm going to try and prioritize them a little bit. But one of the things I wonder about is why there's such a high percentage of crimes that are going unreported, according to the statistics that you've provided here. And I'm wondering whether it's a lack of confidence in the justice system, a lack of confidence in the police system, a lack of confidence in what? Or why would it be that it's unreported? I'm not going to ask you to answer that. I just want to throw that out there. What I would like you to comment on is it seems to me that the only tool that the justice system has in its tool belt is incarceration. And I'm wondering what part in the whole justice system could restitution be incorporated into that? Has your department given any consideration to that?
No, I mean, incarceration is not the only toolbox. I think most criminal charges are disposed of without incarceration. It'll be a fine, it'll be a probation order. The probation order might include a payment of an order for restitution to the victim. The biggest issue with respect to restitution is not the order of restitution, it's the ability to collect it. And of course, so many victims are not getting restitution because of there are no means. There are some programs, Saskatchewan, for example, has some very innovative programs to improve the amount of restitution that is paid to victims. But I'd say that most sentence dispositions in Canada are not incarceration.
Okay. Thank
you. Mr. Rankin.
And I just wanted to clarify again by way of overview the statistics on page 3. The total costs, 31.4 billion in 2008, were for criminal code offenses. So I'm just wondering, are we also talking about controlled drugs and substances here? Are they part of what you are just telling us about today, or not? Or are these simply criminal code offenses? Because I'd like to know about marijuana, the drug courts, etc.
These figures are based on a study that was done using 2008 data called The Cost of Crime in Canada, and it looked at criminal code offenses.
So prosecution of drug offenses is not included in what we're talking about today?
Not the study, no.
I was going to ask you about the breakout of drug crimes in the analysis you're presenting, but in fact, drug crimes aren't included in the analysis that you're presenting. Marijuana, for example, not relevant to this discussion?
I'm not sure. I would have to consult the study once again.
Because you suggested, Ms. McLean, that the youth crime rate is going down, and I wondered if that has to do with the propensity to charge or not charge young people with marijuana as one example. But I can't correlate that at all because we don't even know whether it's included.
No.
Okay. So let me then go to page 15, where you talk about impaired driving cases having decreased. I wanted to know what impaired driving meant. I certainly know it includes alcohol. We have a number, and in fact in my part of the world, an increasing number of people who are driving under the influence of marijuana. And we've certainly read a lot about that in Colorado and the like as well. Would those statistics include, first of all, are there charges for people who are impaired under the influence of marijuana, for example? Would that be included in impaired, or are we to limit this to alcohol impairment?
The statistics don't make a distinction between what was the substance which caused the impairment. It's the Stats Canada records the fact that there was a conviction for impaired driving. That's all Stats Canada has. The circumstances of the offense, whether there was a drug involved alone or together with alcohol, is not in Stats Canada doesn't have that information. So it would include drugs as well. Whatever constitutes a conviction would be captured. But,
thank you.
But there's no breakdown as to what is drug and what is not drug by Stats Canada. There may be other studies that have actually looked at the prevalence of drug-impaired driving, and I think there are some regional ones or city ones, but they're not national stats.
Thank you.
So thank you very much. I'd like to thank both of the witnesses for having come before us today. We very much appreciate your presentations and your answers to the questions. I'd invite you for some of the documents that you said that you would follow up to deliver to the committee. I'd ask you to please send them to the clerk, and then we're going to suspend for the next panel for a couple minutes. All right, we are reconvening and resuming. I'd like to welcome our second panel, which is our double Laurie panel. Probably the only time this year that only Lauries will be witnesses. So from the Department of Justice, we have Laurie Wright, who's the Assistant Deputy Minister of the Public Law Sector, and Laurie Sargent, who is the Deputy Director General and General Counsel from the Human Rights Law Sector, Public Law and Legislative Services Sector. You have one of the longest titles I've ever heard, Ms. Sargent. So I'd invite you to present for
rank, sorry.
I'd invite you guys to present for 10 minutes, and then we've agreed that we'll do one round of questions instead of two, so we finish on time. So please go ahead.
Thank you very much. So it's a pleasure for me to be here today to talk about the Department of Justice's approach to supporting our minister, the Minister of Justice, in performing the examination of government bills and regulations as mandated by Section 3 of the Canadian Bill of Rights, Section 4.1 of the Department of Justice Act, and also by subsection 3, sub 2 of the Statutory Instruments Act. So these examination provisions and the process surrounding them play an important role in promoting the rule of law. First, they require the minister to examine every bill introduced or presented to the House by a minister of the Crown to ascertain whether any of the provisions of a draft bill are inconsistent with the purposes and provisions of the Canadian Bill of Rights or the Canadian Charter of Rights and Freedoms. En ce qui concerne les projets de règlement,
as far as regulatory acts are concerned, the Clerk of the Privy Council has the responsibility of consulting with the Deputy Minister of Justice. The process for reviewing government laws and regulations is not identical, but the goal of the review is the same. The goal is to check whether any provision of the law or regulation is incompatible with the rights guaranteed by the Charter.
Or the Deputy Minister of Justice forms the opinion described by the examination provisions, they must report it, the Minister to the House of Commons after first reading, or the Clerk of the Privy Council after consultation with the Deputy Minister to the regulation-making authority. For purposes of today's presentation, I will focus on the review of government bills rather than regulations. As you may be aware, there have been no reports of inconsistency with respect to government bills since the enactment of the Charter. De l'avis du ministère de la Justice,
from the point of view of the Department of Justice, this illustrates the work that we do with the relevant departments to ensure that bills are compatible with constitutional guarantees. This also illustrates the attempt to strike a balance between the roles and responsibilities of the executive power, the legislative power, and the judge. And the goal is to respect the rule of law. I'll take a moment to talk about the department's work in a little bit more detail.
The Department of Justice play an important role in the development and preparation of government legislation, a process that involves many stakeholders. Department of Justice lawyers provide legal advice to policy officials all across government on how to achieve their policy objectives while respecting the Constitution and all other relevant legislation. Most often, any legal risks identified are reduced or mitigated before they reach Parliament. Justice lawyers are typically involved throughout the policy development process, from initial policy development to legislative drafting, by providing advice on any legal concerns which may arise, including those related to the Charter. To support this important function, the department long ago created a Centre of Expertise on Human Rights. Officials in the Human Rights Law section, for which I'm responsible, ensure that the government benefits from expert legal advice on complex and novel human rights questions, both domestically and with respect to our international human rights obligations. The section also seeks to promote coherence and consistency of legal advice across government on the Charter and the Bill of Rights. Dans les premières étapes de l'élaboration des
In the first stages of policy development, officials work closely with legal advisors from the Department of Justice to deal with any concerns about individual charter rights. Throughout the process, the policy can be adjusted as needed in order to reduce the risk of any incompatibility with guaranteed rights.
Recommendations that are made to Cabinet and take into account all the identified legal risks, including any with respect to compliance with charter rights. For example, where a sponsoring department's options raise significant legal risks, policy officials and Justice Council would report their concerns to senior management for discussion. This would include a discussion of risks up to and including those which would trigger the minister's obligation to report an inconsistency. If the discussions don't lead to changes, the Human Rights Law section will participate alongside other Justice Council in briefing senior departmental officials on the legal advice provided so that discussions at the senior level and the Cabinet table are properly informed. And finally, at the Cabinet table, the Minister herself can again raise any significant legal concerns and advise her colleagues in respect of the constitutionality of the proposal being proposed. Once policy direction is received from Cabinet, the legislative drafting process begins. Les conseillers juridiques des services
Legal advisors from the legal department are specialized lawyers who are specialized in legal drafting. They are also trained to identify any incompatibility between laws and charter rights. In carrying out their duties, these legal advisors work closely with other government lawyers, including those from the Human Rights Department. Again, they try to reduce any risks related to charter rights or any other legal risks that may be identified during drafting.
Council provides final examination from the branch of all government bills for consistency with guaranteed rights in consultation with the Human Rights Law section if required. So as you can see, before legislation is introduced in Parliament, it's gone through a very rigorous review by the Department of Justice. At this point, I'd like to take a moment to speak more specifically about the scope of the duty of the Minister of Justice, who has to report to Parliament any provisions which are inconsistent with the Charter or the Bill of Rights once the proposed legislation is drafted and ready to be introduced. La position du gouvernement.
The government's position on the minister's scope of duty has been adjusted over the years, including by some former ministers of justice themselves. Recently, there was a legal challenge from Mr. Edgar Schmidt. As you may know, we are still awaiting the federal court's decision on this matter.
Conclusion of the legislative drafting phase, the Minister of Justice is of the view that there is an inconsistency between a provision of a government bill and a guaranteed right. It is at this stage that she must report the inconsistency to the House. In practice, this would be tabled after first reading. By its plain language, Section 4.1 imposes on the Minister the duty to ascertain that a proposed government bill is inconsistent with government rights. Given that responsibility, the reporting standard must reflect the wording and intent of the provision. In the case of government bills, the Minister has the duty to ascertain the inconsistency and may do so informed by the legal advice of the Department of Justice and of others if she so desires. Par conséquent, il revient en dernier lieu à la ministre.
Consequently, the Minister can conduct his or her own review based on his or her own evaluation and the related issues.
Long-standing position is that the Minister's obligation to report only arises when there is no credible argument to support the constitutional validity of the legislation. A credible argument is an argument that is reasonable, bona fide, and capable of being raised before and accepted by the courts. This standard requires substantial but not absolute certainty of inconsistency, and it's not based on fixed percentages. As you might suspect, this kind of assessment can sometimes be a challenging exercise. It's made by applying a law to a set of facts at a particular time. However, facts relating to a law's impact can change as society evolves, including facts that speak to either the purpose of the measure, the rational connection between the measure and its purpose, and the proportionality between the nature and scope of rights infringement and the importance to society of the objective that's being pursued. La jurisprudence relative aux droits garantis évolue aussi sans cesse.
Precedence about charter rights also evolves, sometimes in unexpected ways. We've seen a lot of examples of this over time. To give you just one example that Parliament is currently facing, there are the changes concerning physician-assisted dying.
I wanted to take this opportunity to highlight the broader principles that have informed the Department's approach in supporting the Minister in exercising her powers and duties. Under our constitutional system of government, all branches of government, Parliament, the Executive, and the courts have responsibility for ensuring that protected fundamental rights and freedoms are respected. The system of examination put in place by the Department to support the Minister and the Deputy Minister is intended to ensure respect for the role that each branch performs in this regard. The examination provisions mark the outer boundary of when Parliament must be informed that a bill is about to debate is clearly inconsistent with a guaranteed right. However, within that boundary, there remains considerable scope for debate in Parliament as to whether laws may be found consistent with guaranteed rights and the Constitution more generally. So the credible argument standard takes into account the multiple roles that the Minister performs in Canada's constitutional democracy. It's sensitive to the duty to uphold the rule of law and the Constitution while ensuring that the Minister, through the exercise of her statutory duty, does not foreclose legislative debate over policy, except in the clearest cases of inconsistency with the Charter.
Thank you very much for that very clear and coherent presentation. It's been agreed, as I understand, by all sides that we're going to do just one round of questioning so that we finish on time. So we're going to start with the Liberals and Mr. Fraser.
Thank you very much for your excellent presentation. Very much appreciate that. I have a question. Je comprends qu'il y a présentement une...
I understand.
We okay? I realized we're gonna continue. I will fix this the next time. I realize that in this round it's actually the Conservatives that are first. So so if you don't mind, actually, we'll switch it around. So we'll go to Mr. Cooper.
I'll wait.
I apologize. I didn't realize it was different on the second group than the first group. Sorry to put you on the spot there.
Okay. You had mentioned at one point, but I didn't hear you finish your thought, something about assisted dying. I'm on the Special Joint Committee, so it just perked my attention. Okay. But I didn't hear what you were specifically referring to.
I don't believe I made any remarks with respect to the Special Joint Committee.
No, but on the topic of assisted dying, and I didn't hear what the context
simply
was.
to say, sorry, that if we're looking at cases where the law had seemed settled and we received an unexpected decision from the court, that would have been the Carter decision, which has now led to the Special Joint Committee that's looking at that issue.
Thanks for that clarification. And you provided a fairly comprehensive overview of the process and analysis that takes place with respect to legislation to ensure Charter compliance. Are there any changes to that process that are envisioned at this time?
I think we're at the departmental level quite satisfied that we have an entirely robust and well-functioning system in terms of how the advice is given, how it is reflected in the policy development process. As I mentioned in my remarks, at the end of the day, it's the Minister's responsibility to make her final decision on what she feels with respect to whether a bill meets the standard in Section 4.1 or not.
And that standard again is credible, bona fide, and what was the other criterion?
So the way we look at it is that it has to be, yes, a bona fide and reasonable argument that's capable of being accepted by a court.
I will designate the balance of my time to Mr. Fall.
Thank you. Thank you, witnesses, for coming here this morning, Ms. Wright and Mrs. Sargent. Wondering if you can give us a little bit of a report on the frequency of incidents that this has actually happened in the past.
Well, I can say in terms of the role of the department, we're certainly involved every time that there is a memorandum to cabinet that's being prepared with respect to a proposal for new legislation. And so the review for all legal risks, including those related to the charter, would take place every time that a legislative proposal is under development, either during the policy development phase, at the phase of the memorandum to cabinet, or during the drafting phase. So we're certainly involved consistently every time legislation is being prepared.
Okay, thank you, and I appreciate that answer. If I understood you correctly, though, the minister has an obligation to report to the House anytime government legislation contravenes the charter or the Constitution. Can you report on how often that has happened?
Certainly. So because of the high threshold for the report, there has never been a Minister of Justice who has ever made a report under this section. So when bills are tabled, there is a certification that they have been examined for compliance with the Charter, but a report under Section 4.1 has never been made.
I haven't been here that long, but that's the way it would seem to me. I can't imagine a Minister of Justice producing that kind of report in the House of Commons against her own government.
So we feel that it's a mark of success with respect to adjustments that are made to policy proposals as they're developed, that we have indeed never come to that impasse where a minister would be at odds with her cabinet colleagues with respect to the constitutionality of legislation.
Okay, and as a Justice Department, you've never had cause in the past to think that that should have happened?
So it's the minister's decision at the end of the day with respect to advice that the department provides. I think we have a pretty good track record of managing to work with clients in order to address those risks before it would get to that stage.
Okay, and then a little further, this is something that only applies to government legislation, does not apply to private members' business.
That's correct. The obligation in the Department of Justice Act does not apply to private members' bills. I understand that there is a House committee process that looks at private members' bills before they're put forward for eligibility for the list that does look at constitutional issues, but that's not an obligation on the minister.
Okay, thank you very much. Mr. Chairman.
Thank you very much, Mr. Falk. And now, Mr. Fraser, and I apologize to both sides. I didn't realize that we reversed on another panel.
Thank you very much, Chair, and again, thank you very much for coming in and for your presentation. I
understand that there's currently a bill, C-452, which aims to modify the criminal code so that there would be consecutive sentences for offenses involving human trafficking and human exploitation. Could you comment on that bill, which may be ruled inconsistent with the Charter? And could you comment on its possible connection to Section 4.1 of the Department of Justice Act?
So because this provision is a private member's bill, it's not covered by the scope of Section 4.1 of the Department of Justice Act. So the minister does not have a responsibility to report with respect to private members' bills. On the question of the constitutionality of the bill itself, unfortunately, I'm not in a position to be able to provide legal advice to the committee on that. But I would recommend that you can turn to your law clerk of the House.
Okay, thank you. With regard to legal opinions and sought by the Minister of Justice under 4.1 of the Administration of Justice Act, so the legal opinion is given from within the department, is that correct?
So we certainly do provide considerable advice. We're not the only source of advice on which our minister or other ministers are entitled. So there is a process for seeking advice from private firms if a minister would want to do so. But clearly the bulk of the advice that our minister receives would come from within the Department of Justice.
And just one final question. With regard to that legal advice, is that subject to privilege?
Yes, so the Crown is considered to be the same as a private person when she is consulting her counsel. So there is solicitor-client privilege, which respects the confidentiality of that advice.
All right, thank you very much. I don't know if my colleagues have questions.
Yeah, any other, Mr. Sen?
Thank you, Mr. Chair. Thank you for coming in and giving us a really good presentation. Just have a quick question with respect to the courts declaring laws to be contrary to the Charter in recent years. Due to the frequency of those decisions in recent years in which the courts have declared laws to be laws to be contrary to the Charter, what are we to conclude about the efficacy of the Section 4.1 reviews? And my second question is, how can those reviews and how can that efficacy be improved so that we have less laws being ruled contrary to the Charter by the courts?
Sure. So I think there are several things to keep in mind. So many of the provisions that have been struck down in recent years from the courts are relatively old provisions, which would have predated the Charter and predated the obligation on the minister to report. So that's one factor certainly to keep in mind. I think it's also important to note that there have been a number of important successes with respect to defending Parliament's laws before the courts in recent years as well, and there are some examples that come to mind, such as the security certificates regime, some terrorism offences in the criminal code. The other thing to keep in mind is that the law is in constant change. And even when you look at the progress that one case makes going from its trial level all the way up to the Supreme Court, you may find that reasonable people, i.e. different judges who are sitting on the cases, will take different approaches to the same issue. So you may have, for example, at a trial level, a court which says something is not constitutional, but when it's appealed to a court of appeal, the court of appeal will disagree and uphold the law. On an appeal panel, you will have more than one judge, and so you may have some judges who disagree even within the same panel about the constitutionality of the legislation. So this puts us in a situation as lawyers of acknowledging that what we do is art and not science, and so it's hard to come up with in every case, a level of certainty that something is not going to be struck down by the courts.
Any further questions from that side? If not, can I just ask, because we have 1 minute left, one small question. Just for clarification, you said there's no percentage basis on the 4.1 subsection 1 decision as to whether or not a report is required, but let me ask, in the event that you would find that the preponderance of the evidence would conclude that there would be a Charter violation, would you deem that then a requirement to report, or could you still say, even though it's 60% or 70% chance that the Charter is violated here, there's still a bona fide chance that there will not be a violation, and as such, the legislature should be allowed to go ahead and do what it wants without advice?
So I think when you get to the reporting standard, it's looking at it a little bit from the other way around. So it's not to say that there might not be impacts on rights and freedoms, and that the government doesn't have a case that it wants to make for justifying that impact. The question is, have you crossed over the threshold where a lawyer would not be able to make the credible argument in court in order to be able to try to justify the legislation?
So at that point, you could have such a very tiny, as long as you can make a credible argument, you could say, well, I think it's a 10% chance that it'll be upheld, but I can make a credible argument. It's still, okay, I understand. Mr. Rankin.
Thank you, and thank you. I'd like to continue on that vein, if I could. I can understand, as Mr. Falk pointed out, how unlikely it would be that in the 31 years of this requirement's existence that a minister would stand up and actually table something that's saying this is inconsistent with the Charter. But what the Schmidt case seems to be showing us, so I take it we still have to wait for the court's decision, is that the standard is just much too low. I mean, my opinion is that the standard is ridiculously low. Apparently, it's whether it is, quote, manifestly unconstitutional and could not be defended by credible arguments before the court, close quote. So whether it is a good chance that a provision would be found unconstitutional, more likely than not, as the chair said, that's the standard that I would argue needs to be there, rather than some 10%, 20%. I know you don't quantify it, but that's what Mr. Schmidt asserted, and that's what's before the courts in that decision. I mean, it seems to me that the standard is very low, and if one looks at the number, the amount of time and money we've spent, federal government losing cases about the charter in the last few years, the proof is in the pudding. I would assert to you.
So there are certainly different approaches that can be taken. So I think the idea behind the standard here is that it's only in the clearest of cases that you would want essentially the executive to prevent Parliament from being able to have a debate as to whether it wishes to go forward with a certain piece of legislation representing a certain policy solution to a problem. And that the report that a Minister of Justice might make is not the only source of information that's available to parliamentarians when they're considering legislation as to the questions of constitutionality. So certainly there is the law clerk for the House, there's the law clerk for the Senate, and in addition to that, of course, at committee hearings, there is often a wide variety of witnesses who appear, who offer their views with respect to the legal issues, including constitutional issues on bills. So I believe that the purpose of the standard that's been adopted is in order to recognize the important roles that each of the branches plays and not to foreclose democratic discussion.
Have you had a chance to compare the standard that exists in 4.1 of the Department of Justice Act with similar provisions across the country to see whether they're applied in a more rigorous fashion? Anecdotally, that appears to be what's happening.
So Section 4.1 in terms of Canadian standards there are no different, there's no comparable provisions across the country with respect to the provincial legislatures. There are some international comparators, and I can perhaps ask Laurie Sargent.
When you say there's nothing comparable, in British Columbia, this is done routinely for regulations as per the Statutory Instruments Act and for legislation. It's routinely done by Attorney General lawyers. So whether it exists as a practice or whether it is in statute, and they provide I'm told, a much higher standard than what exists under the federal 4.1 rule.
We'd have to review again more carefully, but my understanding is that that would be their role as Attorney General, which of course we also fulfill in advising all the time consistently as to what the likelihood of an adverse outcome would be, but it's not a statutory obligation on the Attorney General, the Minister in BC, to report in the same way that we have here. Maybe if you would indulge, the international examples are interesting. If you look at New Zealand, they have a similar statutory obligation, but it is phrased quite differently and talks about the minister reporting when something appears to be inconsistent. And elsewhere in the United Kingdom, in Australia, there are different types of standards where ministers or attorneys general are reporting on compatibility as opposed to reporting on something being inconsistent. So it's just important to remain mindful of the way in which Section 4.1 is framed, and that has, of course, influenced the way it's been interpreted. The issue is before the courts, though, and we will see, of course, how the federal court rules.
I would just say that as a matter of public policy, we're spending a lot of money losing cases on the charter in the federal government in the last while. I can think of many examples, mandatory minimum sentences, the Insight case, and so forth. To think that the check is working seems to me to be wildly counterintuitive. And I would just suggest that one of the things this committee ought to do is examine whether a better standard would allow less cases to get through the sieve than gets through now, because it's certainly costing Canadians a lot of money to lose these cases. It's just my my comment, Chair.
Thank you very much, Mr. Rankin. And just one small clarification question again, and I'm sorry to do that. I understand that there's a review done. Laws then come to committee. Let's say this committee, for example, in the case of the assisted dying law, was to amend the proposed legislation. would there be a re-review of Section 4.1, subsection 1, after a committee made an amendment to a law?
So the review would be done when the bill is tabled.
That's right.
Before the government proposed, if the government was proposing amendments in committee, there would be another review that would be done internally of the amendments at that time. Obviously, amendments that come from other parts of the committee wouldn't be subject to a reporting obligation, but advice could be sought.
Okay, thank you very much. And I think we've now gotten to exactly when we're supposed to close. So I'd like to thank all the members of the committee for their good questions. I'd like to thank the witnesses for their excellent presentation and their clear answers. Meeting adjourned.